right, we're going to continue with Chapter 7. We're on subsection C, where we're talking about transferring the tenant's interests. There are two types of mechanism a tenant can use to transfer her rights that come with the lease. The first is by assignment, and the second is by a sublease. Now, it's important to distinguish between whether or not a transfer has been made as an assignment or a sublease, because there are legal consequences to each type of transfer. So before we can distinguish between an assignment and a sublease, I would like to explain some background concepts. So these are just some definitional, some definitions that I hope will help you understand when we talk about assignment and sublease a little bit more. Okay, so the first is privity. Privity is a legally recognized relationship between two parties. Again, privity is a legally recognized relationship between two parties, okay? So, aside from privity, there is another concept that we bring up in property often. We're going to go into it in much more detail, I think, in Chapter 10. But I just want to introduce them here, and that is a covenant. A covenant is a promise to engage in or to refrain from doing an act. Again, a covenant is a promise to engage in or refrain from doing an act. All right. When it refers to real property, we oftentimes call it a real covenant. All right, now that we have those definitions out of the way, whenever you have a tenancy, you are going to have two privities. The first privity is the privity of contract. Remember, privity means relationship, right? So we have a contractual relationship. And I use K to represent contract. So there are going to be rights and duties under this contractual relationship. But you also have a privity of estate. A privity of estate is another type of relationship. Privity of estate refers to the legal relationship that the land occupant has with the person who is next entitled to possession. I'm going to repeat that. It is the legal relationship that the land occupant, in this case, that's the lessor, the land occupant, has with the person who is next entitled to possess the property. Okay? So you have rights and duties that arise from the privity of estate, just like you have rights and duties that arise from the contract. All right, so even if we didn't have contract law, and you didn't have rights and duties under the contracts, you would have rights and duties under privity of estate. Another way to think of it is Privity of contract deals with contract law. Privity of estate deals with property law. So this diagram represents the relationship between a tenant who has entered into a contract with their landlord to lease a property. That results in two relationships, the privity of contract and the privity of estate. So then what happens if the tenant decides that they want to transfer their property interests to another? Let's say, for example, the tenant has outgrown their space, but they still have another year on their commercial lease. Let's say they entered into a 3-year lease. They have found somebody that is interested in the property and they want to transfer their property interests to another person. How can they do that? Well, they have two mechanisms that they can use. We already said it's the assignment and the sublease. What is the difference between the two? If the tenant decides to use an assignment or to assign their interest to an assignee, then they are giving their entire interest in the leased premises to the assignee. Nothing is left over. So they're giving this assignee their entire interest. Then they enter into a contract with the assignee. So they have privity of contract. The lessee or the tenant and the assignee have privity of contract with one another because they're entering into a contractual agreement where the assignee is taking over the property interest of the tenant. Because that assignee is going to have possession of the land, they also are going to have privity of estate. So, and the tenant no longer has possession. So they can't have privity of estate anymore. So instead, the privity of estate flows from the landlord to the assignee. What does this mean practically? Well, it means that the property rights that flow with the land go to the assignee. And the assignee and the landlord then have rights and duties based on this privity. When we say that the rights or duties flow with the land, what we are saying is that they are rights or duties that are related directly to land use or enjoyment. The tenant still has a contractual duty to the landlord. They have not severed this relationship, so they're still on the hook to perform under their contract, or to guarantee the performance, rather. And the assignee has contractual duties to the tenant. But the assignee does not have contractual duties to the landlord. Does that mean the assignee doesn't pay rent to the landlord? Well, no, the right to collect rent is a right that goes with the privity of estate because it is a right that flows with the land. It touches the land. It has to do with the enjoyment of the land. It does mean, however, that their failure to pay might fall on the tenant. So the tenant might be liable for the assignee's failure to perform their duties under the privity of estate. And and that's based on the privity of contract. Super confusing, I know. If you're not confused yet, you just wait. It's about to get even more confusing. So this was the relationship with an assignment. Now we're going to look at the relationships that are represented by a sublease. All right, again, we have the landlord that leased to the tenant, and as a result, the landlord and the tenant have privity of contract, privity of estate. The tenant decides they want to sublease their interest, to transfer their interest through a sublease. What does that mean? Well, if they transfer their interest through a sublease, it means that they have not transferred all of their interests. Usually, it means they retain a reversion. So, for example, let's say the lessee or the tenant has a 3-year contract and they enter into a contract with the sublessee and they say, look, for the next 1 year, you can occupy the premise. And then after, we'll come back and take the property. In a case like this, the privity of estate flows from the tenant to the lessee, the tenant to the sublessee back to the tenant. So you can think of it this way. So the lessee is passing the privity of estate to the sublessee, and when the sublessee is done, they are passing the privity of estate back to the lessee. I hope that helps. So essentially, this arrow represents the passing back and forth of the privity of estate. So this is what it looks like for a sublease, right? Alternatively, if we had an assignment, it would be privity of estate between the landlord and the sublessee, and there would be no privity of estate here. So you can think of it as the assignee we're an assignment, the assignee would have the privity, and then they would pass it back to the lessor when they're done. So that might help you remember if you think about somebody who has current possession of the property is always going to be one of the parties with privity of estate, and the second party is always going to be who gets the remainder, who gets the reversion. And so in the case of an assignment where there's nothing left, it makes sense that the privity of estate would be with the landlord because the property is going back to the landlord. On the other hand, if we have a sublease and there is something left for the tenant, then the privity of estate we have two privity of estates. The sublessee is going to give the property back to the tenant, and eventually the tenant is going to give the property back to the lessor. Okay. Hopefully that clarifies things a little bit. Now let's discuss Ernest V Condit. This case introduces the difference between assignment and sublease. The facts of the case are a little bit complicated, so I'm trying to diagram them out here. Ernest is a landlord, and he leased the property to Rogers. So there's privity of contract between Ernest and Rogers. Rogers then assigns all of his interest in the lease and a 2-year extension that was negotiated with Ernest to Condit. I think that's how you pronounce. Condit only made 4 payments, but remained in possession for the entirety of the term. So Ernest is suing Condit for the balance of the rent plus the cost of removing the improvements on the property that Rogers had put on. So the court is having to decide whether this transfer from Rogers to Condit was a assignment or a sublease. I want to clarify something here about the rule, the majority rule. So the majority rule is that if all interest is transferred, then you have an assignment. So Tennessee has follows another rule, which is a kind of a minority rule, essentially, in which the court doesn't only look to see that all the interest has been transferred, but also looks to see whether the right to re-enter has been transferred. And so you can only have an assignment in these jurisdictions if the right to re-enter has been transferred. In the majority of jurisdictions, the tenant can retain the right to re-enter and it still be an assignment as long as all the interest in the land has been transferred from the tenant to the to Condit in this case. Now, why might a tenant want to retain a right to re-enter even if they transfer all of their interests? Well, a tenant might want to retain a contingent right to re-enter just to make sure the land is taken care of. So, for example, let's suppose that L leases an apple orchard to T, and then T transfers his interest to X. To minimize the risk of liability to L for waste, T might want to retain a contingent right to re-enter so that T can care for the apple tree if X fails to do so. So, even if Rogers transfers all of his interest to Condit, he still might want to retain a right to re-enter. But in Tennessee and other minority jurisdictions, they don't allow that. I'm only going to test the majority rule on your exam, so I'd focus on that. For the purpose of this case, we're going to explore this whole additional requirement for an assignment. So in this case, Ernest's theory is that Condit is an assignee of the lease, and therefore he's liable to him for unpaid rents. Because if he was indeed an assignee, then there would be a privity of estate between Condit and Ernest. Condit's response is he is merely a sublessee, and so he owes no privity of estate to the landlord, and he only is required to pay rent to Rogers, and Rogers keeps his privity of estate. So what support do they have? Do they each have? Well, in favor of the argument that this is an assignment, Rogers did transfer all of his interest over to Condit. Well, what supports Condit's argument that it is a sublease? Well, Condit argues that Rogers retained and impliedly retained a contingent right of re-entry, meaning it wasn't written explicitly in the contract, but it was an implied right to re-enter. And he based this argument on the fact that Rogers represented that he would still, quote unquote, remain on the hook for the contract. Honestly, it's a pretty weak argument, right? Because Rogers, regardless of whether this is an assignment or a sublease, Rogers is going to be on the hook for the contract, right? Because both of those diagrams contain this privity of contract here between the landlord and Rogers. That remains regardless if it's a sublease or an assignment. The only time you can get rid of this is if you do a novation, which is a contractual term. We're not going to go over novations. But for an assignment or a sublease, that privity of contract is going to be, it's going to remain. Plus, the amendment, the contract that assigned everything to Condit did not contain an explicit right to reenter. So if we had used an objective standard, even if we were in a jurisdiction that defined assignment in this way, that we still would have met it. We still would have met the requirements. But instead, this court uses a subjective standard where they look to see whether it was Rogers' intention to retain the right to reenter. So they try to look and figure out what the intent was as to retaining the right to reenter. Apologies, I failed to state one major piece of evidence that Condit pointed to suggest that it was a sublease, and that was the use of the term subletting in the contract. So Condit argued that even if the contract did not have an explicit right to reenter, it did have this implicit right to reenter because the word subletting was used in the contract. The court didn't buy this argument. Even with the subjective standard, they said, we think that they didn't mean to maintain a right to reenter by using the word subletting, and so we have an assignment. Because we have an assignment, that means that Condit is going to be liable to Ernest for payments based on privity of estate. If you don't like this case, I'm right there with you. I don't like it much either, but it is here and we are going with it. So what do you need? What do you need to know for exam purposes? Well, the thing to take away from that case is that there is an objective test for assignment, and that objective test, the tenant transferred all of their property right to possession for the remaining lease term. If you find that, then you find that there is an assignment. And in most jurisdictions, even if you keep a contingent right of re-entry, this is still considered an assignment. Using the subjective test, the distinction between assignment and sublease depends on the intention of the parties. How about some hypotheticals? In these problems, we're going to determine who owes rent to L. And assume L leased to T for a term of 12 years, beginning in 2012. Start with problem number 1. Let's say in 2013, T assigns to B. Then in 2014, B assigns to C. And then in 2016, C subleases to D. Who owes rent to L? I highly suggest drawing these out. So this orange line represents the privity of contract. So when L leases to T, the privity of contract is there. And here is the privity of estate. And remember, privity of estate runs with rent. Rent runs with the land, so it's part of the privity of estate. When T transfers or assigns to B, the privity of contract flows to B, and then B assigns to C, so we have the privity of contract there. Then we have C subleasing to D, and so we have a privity of contract here, but I represented it by red. So once T assigns to B, the privity of contract goes from, privity of estate goes from L to B. When B assigns to C, it goes from L to C. But when C assigns subleases to D, when C subleases to D, the privity of estate does not travel, right? We have an additional privity of estate from C to D. So if you're looking to see who owes the rent in this problem, you look to see who is tied to L with privity of estate, and that is C. C is primarily responsible to pay rent to the landlord. D is responsible to pay rent to C, but C is responsible to pay rent to the landlord. Let's do the next one. In 2016, T assigns, subleases, and transfers all of my interest in the lease to A. Who owes rent to L? If we apply the objective test here, then this transfer is an assignment because T transferred all of his interest to A. So T is liable to L under privity of contract, and A is liable to L under privity of estate. It might help you to diagram this one out as well. All right, number 3. In 2016, T transfers all of his rights in the lease premises to E for a period of 5 years. Who owes rent to L? So to answer this, you have to go back and look at the original terms of the lease, which began in 2012. So in 2016, there was a term of 8 years remained on T's original lease because T transferred the right to possession to E for only 5 years. That means he retained a right of possession for the final 3 years. And under the objective test, this transfer is a sublease. Why? Because he retains a right of reversion. And so T is only liable to L for rent in both privity of contract and privity of estate because this is a sublease. So in this video, we talked about how a tenant can transfer their rights and interests. And at common law, they had unfettered ability to do this transfer. But now, oftentimes, in a contract, the landlord will put stipulations or will prevent the tenant from transferring the property without the consent of the landlord. So we're going to next explore some of the different ways a landlord can put restrictions on the tenant's abilities to transfer the property.